Namaste ji, namaste. Welcome to Courtroom. I sincerely hope that you're doing well. Now, this is one extremely high probability topic that will most likely show up in CLAT PG 2024 when you will be attempting it on the 3rd of December. This year, if they do not ask it this year, which is highly unlikely, they most likely will keep it for next year. Now, this judgment was clarified on the 31st of January 2023, and as you know, with CLAT PG, you need to be through with the most important, the major Supreme Court judgments of the year to, let us say, cover out at least 40% of the paper, because it is a very miscellaneous sort of a paper in which you need to have your general legal knowledge in place. As in legal knowledge, when I say legal knowledge as in sections, etc., then you need to have covered legal current affairs and then think about the questions that they can ask you. So we are starting with Joseph Shine versus Union of India. So the original judgment was delivered on the 27th September 2018. Write down the date. It decriminalized adultery. The case name, they can always forever ask you this question. This is in fact a standard. DULLB में तो पहले बहुत बार ही पूछते थे, but since now the DULLB has died, so certainly they won't be asking there anymore. And CLAT UG also till 2019, these sort of questions were quite, you can say, high probability back then. Okay, so when we have decriminalized adultery, which is the relevant section of the IPC, so that is section 497 of the IPC. Whenever you say IPC, you go back to 1860, and 1860 ke saath saath the author of the IPC, TM, not trademarks, Thomas Macaulay, and the first chairman of the pre-independent era, pre-independence era law commission, again Thomas Macaulay, who authored the Indian Evidence Act, James Stephens, and आपके James Stephen के बाद the Indian Contract Act was crafted on the recommendations of, I think, the third law commission, if I'm not mistaken. All right, so the decision was given that section 497 violated for Article 14, Article 15, Article 21. When you open the original judgment, that is 2018 की judgment, उसके अंदर Justice Deepak Mishra in the very opening paragraph mentions the golden triangle of the Constitution, that is 14, 19 and 21. The final decision was that 497 and 198 subsection 2 of the CRPC, they were violative of Articles 14, 15 and 21. So this is an MCQ. I am teaching this topic primarily from the point of view of CLAT PG, of what all can they ask you since this has taken place this year. So the final observation of the court, as in the clarification, was delivered on the 31st of January 2023, this year, the year in which I'm shooting this. So bench, if you go through 20, 21, 22 and 23 ka paper, CLAT PG, you have 4 past years available with you. You'll always find that they have a tendency to ask who was sitting on the bench, and let us say if there is someone has dissented, well then who dissented, under what provisions is a dissent provided for, etc. They tend to ask this. So CJI Mishra back then, who wrote a concurring, so everyone concurred, there was no dissent. So Justice CJI Mishra, who wrote and basically the judgment on his and Khanwilkar Judge Sahab ke behalf pe, Justice Nariman was there, DYC was there, and Justice Indu Malhotra was there. Justice Indu Malhotra famously dissented in the Shabrimala judgment. Shabrimala judgment, I think, wo Indian Young Lawyers Association wali, I think they've already asked about it in the 23 ka paper that took place in December 22. All right. So judges ke naam become important. This is how you make short notes basically. PIL is this Joseph Shine wali jo case is a PIL, so it's a public interest litigation. Public interest litigations are filed under Article 32, also known as heart and soul of the Constitution, described as by Dr. B.R. Ambedkar. Article 32 is a right to constitutional remedies given under Part 3 of the Constitution. Part 3 goes from Article 12 to 35. All of this needs to be on your tip because CLAT PG is quite constitutional law heavy. If you've noted it, around 30 to 40% of the paper pertains to the Constitution. Then they end up going into, let us say, a judgment has come in on, it's related to the CRPC, etc. Then, well, relevant provisions or relevant questions are asked from there. Okay. Now, the relevant section from CRPC, I call it RS always. Relevant section from CRPC is section 198 subsection 2, which says, the title jo hai, that again is important, that is prosecution for offences against marriage. CRPC ke saath hamesha saal to yaad rakhna hai, that's 1973, and no person other than a husband who will be eligible to file a complaint. So both the sections were challenged, both the sections were, the court had also observed that Usually criminal law is gender neutral, but that doesn't seem to be in this very case. Alright. Now 497 was already upheld in that it was not violating any provision of the constitution in Somitri Vishnu versus Union of India, V. Revati versus Union of India, Yusuf Abdul Aziz versus State of Bombay. You can pause this lecture here, ये तीनों case law लिखने पड़ेंगे. Now let us say what is the sort of an MCQ that the examiner can create, in which of the following case laws or which of the following case laws is not related to section 497. ये चौथा एक और option दे देंगे जो random होगा, and these three. Now when a student next year will look at it कि भाई इतने सारे ऐसे कैसे cover होंगे, इतने सारे cover करने की ज़रूरत नहीं है. This is just, these are the cases in which, so these are the precedents that were referred back to in the judgment. So you need not, for every year go down and dirty phone हर section की सारी judgment आप उठा के कितनी कर लेंगे. It is humanly impossible to cover it out. Alright. So in 3 में 497 has already been upheld. Now we go to 497 itself, and then we'll go to the core crux of why this application had to be filed and how this application almost is like a review, you can say, but the Supreme Court also noted the fact, but then it decided कि कोई बात नहीं, we'll just clarify it. And 497 section number तो याद रखना ही रखना है. Adultery, IPC 1860. Whoever, anyone, has sexual intercourse with a person who is and whom he knows or has reason to believe to be the wife of another man. The key ingredient, without the consent or connivance of that man. So consent is important. Consent of that man, perhaps if given, then the offense is not of that of adultery. Such sexual intercourse not amounting to the offense of rape is guilty of the offense of adultery. Now imprisonment, since adultery के बारे में बात हो रही है, इस साल तो याद रखनी ही पड़ेगी. Usually DGS prelims में तो एफरे की punishment. अब जैसे for example legal current affair इस बारी फिर adultery उठ गया. अब जब भी DGS prelims होगा, we'll just have to revise the punishment terms. Either description for a term which may extend to 5 years or with fine, because this is a relevant MCQ for specifically for this year. Now when again a student analyzes the past years or successive years, he'll be like, अरे इतने adultery की अगर punishment पूछी है, so might as well, I'll just rote learn all the punishments. That is not required, but especially for CLAT PG, because this paper is slightly random on those terms, and you can't really be rote learning all punishments for all sections just because once it has been asked. Hopefully this is asked. Alright. So November 20 May, the Union of India, who is the original respondent in the case, filed a miscellaneous application that whether the judgment applies to armed forces, and it referred to Article 33 now. Now Article 33 therefore becomes important. Article 33 falls under Part 3 because we are going from Article 12 to 35 in that part, and Part 3 is fundamental rights. Part 1 is the Union and its territory. Part 5 is the Union. Part 2 is citizenship. Part 3 is fundamental rights. Part 4 is DPSPs. Part 4A is fundamental duties. 42nd Amendment 1976. Swaran Singh Committee. 11 fundamental duties right now. Duty number K added by the 86th Amendment, I believe in 2002, which made the right to education as a fundamental right as well. You need to have all this on your tips if you wish to reasonably have a fair shot at attempting CLAT PG and score good marks. Alright, so Article 33, Parliament may by law determine to what extent any of the rights conferred by this part, which part are we in? We are in Part 3, shall in their application to the members of the armed forces, the members of the forces charged with the maintenance of public order. What are these? Who are these? The police, perhaps, the CRPF, other forces, persons employed by any bureau or any other organization established by the state. State, Article 12 started with state, that anytime state is referred to in this part, it will mean the state as defined in Article 12. For the purposes of intelligence or counterintelligence, or person employed or in connection with the telecommunication system set up for the purposes of any force, bureau or organization. So telecommunication systems, this is a standard MCQ as well, that Article 33 applies to who. So this is a popular MCQ from DU, LLM, that also has died because CUT PG has taken over, but DU, LLM and ILI etc. institutes used to ask Article 33 के बारे में. Now यहाँ से sentence connect करते हैं. So Parliament में, the Parliament has the power to restrict fundamental rights of these guys. We restrict or abrogate it so as to ensure the proper discharge of their duties and the maintenance of discipline among them. So Article 33 के तहत Parliament has the power to abrogate their rights. Now we come here कि दो मुद्दे, the basically core crux of the issue in this miscellaneous application that was filed. The Supreme Court said, well, is it like a review, because सामने वाले, on behalf of Joseph Shine, this was argued, and on behalf of the interveners it was argued that is this really a miscellaneous application or is this a review? The Supreme Court referred to Delhi Admin versus Gurdeep Singh Uban, UBAN judgment के अंदर लिखा हुआ है, and the answer was no. But more importantly than that, I don't think that they will go into these details. This is very very tiny, minute details. But herein, the most important bit is Section 45 of the Army Act and Section 63 of the Army Act. That is where the entire, you can say, the main, informally, not legally speaking, the cause of action lies. Now it says Section 45 of the Army Act 1950 says, unbecoming conduct, any officer, junior commissioned officer, or warrant officer who behaves in a manner, no need to rote learn the section, just rote learn Section 45 in the Army Act. Just for this specific year, you do not need to open the Army Act and Navy Act and go through all these sections. No other MCQs will be asked. These are the relevant sections. I think one more section is referred to in Section 69, but I didn't find it to be very highly probable. So Section 45 is unbecoming conduct. So in this, the argument was that if you have removed Section 497 and if an officer engages in adultery, and if we want to prosecute him via court martial, we won't be able to do so thanks to your judgment. Your as in the Supreme Court's judgment. So Supreme Court said, look buddy, we never really commented on Article 33. We were not asked to give a judgment on Section 45, and Section 63 says, violation of good order and discipline. Any person subject to this act who is guilty of any act or omission which, though not specified in this act, is prejudicial to good order and military discipline, shall on conviction by court martial. So they said, look, so the main issue is that if we are unable to get the officers into discipline, if let us say that tomorrow they commit adultery and we want to, let us say, prosecute them in the army, so I'm speaking on behalf of the army, we won't be able to do so because adultery is no more of an offense. So now, can you please tell us, so we've asked the Supreme Court this question, that your judgment is fine, we're not challenging the judgment, we're not asking you to review it, but can you please tell us that whether your judgment of Joseph Shine versus Union of India, it affects Section 45, Section 63, basically our power to keep these guys in check, because otherwise tomorrow their counter argument will be Section 497 is not an offense. How are you applying these sections to us, and how are you asking us to remain in discipline even if we have committed adultery? So Supreme Court said, look, our judgment is primarily related to the IPC. We're not commented on Article 33. We were not asked to look into Section 45. Not asked to look into Section 63 of the Army Act, and then relevant provisions are in the Navy Act, relevant provisions are in the Air Forces Act as well. All of these, you can prosecute them for adultery. If they engage in adultery, they won't be prosecuted under the IPC, as in specifically the officers. But if you want to, well, initiate proceedings under these sections, go ahead, do them to maintain order and discipline in the army. All right. So therefore, Section 63 is साल के लिए, Section 45, in fact Section 69 as well, but not really in depth. Article 33 becomes important, all right. Then आपका 497 adultery के ingredients become important, the punishment become important. These three case laws के केवल नाम, no need to go into the facts, no need to go into the kahani that was there. Just remember that 497 was upheld in these case laws. And आपका which section from the CRPC? That is Section 198 subsection 2, who were the pioneers of PIL, Krishna Iyer. I think I forgot to tell you this in the lecture. Krishna Iyer and Bhagwati. And Krishna Iyer was never the CJI, which of the following was not the CJI? Krishna Iyer was never the CJI. This is a standard law entrance ka question. PILs filed under Article 32, again given in Part 3. Bench strength, CJI Mishra, Kamvilkar, Justice Nariman, DYC, and Indu Malhotra, who dissented in Shabrimala. I think she headed the committee, fantastic judge in fact. She headed the committee that was overlooking PM Modi's security breach in Punjab, wo jo inko jo पुल पे जो रोक लिया गया था, traffic jam. And Joseph Shine versus Union of India, well, decriminalized adultery, Section 497 IPC, violated Article 14, 15 and 21. That's how you quickly dissect a legal current affair and think about what all can they ask you in CLAT PG to make life easier for you. I'll try to upload more lectures. We had to start an online course on CLAT PG, but I'm planning to do so soon. If I'm able to do justice to this exam, I will announce it very, very soon, in which we'll just cover out the latest Supreme Court judgments, and we'll cover out Constitution, we'll cover out IPR, we'll cover out a chunk of subjects so that you are thoroughly prepared कि कौन सी भी judgment का कौन सा भी excerpt ले आओ. Like for example contingent contracts, wagering contracts etc. जैसे पिछले साल भी था वहाँ पर, I think पिछले साल था, पिछले साल था. You need to know them any which way, whether a judgment excerpt is given or not. So I think you can fairly score, I think 120 में से you can fairly score 120 MCQs में से you can fairly score a 70-75ish easily. 60 to 70 का तो chance बनता है. Then the more your prep level is, then you go into the ranges of 90 और उसके ऊपर then it becomes totally a game of what all you prepared and how much it showed up in the question paper. Alright, wishing you all the very best. See you soon. Hopefully this has been of help to you. Alright, take care, bye.